My name is Taun, a research fellow at the Center for International Law and a moderator for today's webinar. CIA organized 3 webinars on MAS last year. Following those webinars, today we will talk about updates on the discussions on MAS and the law of the sea. Today we have 2 distinguished speakers on MAS and the law of the sea. The first presenter, Ms. Pia Benosa, will present on recent developments at the IMO. And the second presenter, Professor Beckman, is going to talk about the implications of MAS for the 1982 Law of the Sea Convention. If you have any questions during the presentations, please type them into the Q&A box at the bottom of the Zoom screen. We will discuss the questions after the presentations. Without further ado, I would like to welcome Dr. Nilüfer Orer, the Director of the Center for International Law, for opening remarks. Nilüfer, you have floor.
Thank you. Thank you, Dawoon. And it's my great pleasure as Director of the Center for International Law here at the National University of Singapore to extend a very warm welcome to all those who are joining us from different parts of the world. It is really a pleasure and an honor to have you with us today, and particularly on a topic that is of great importance and relevance, international shipping and maritime autonomous surface ships, and an area that CIL, through the Oceans Law and Policy Program, has been really working very diligently on. And I have to recognize and acknowledge that we have been supported by a grant to work on this critical issue from the Singapore Maritime Port Authority through the Singapore Maritime Institute. So I take this opportunity now to thank them for their continued support on this. We have, of course, today Dawoon, who is a research fellow with us, has already introduced the speakers, but they are all, of course, experts in their own right. But may I say we're especially pleased to have, of course, our own Director of the Oceans Law and Policy and founding director of the Center for International Law, Emeritus Professor Bob Beckman, who is really one of the world-leading names in law of the sea and shipping matters. And he is definitely raising the next generation of experts who are with us today. So without further ado, I wish you all an excellent webinar. And I'm sure you'll have a very good discussion at the end. Over to you, Dawoon.
Thank you, Nilüfer. Now, I would like to invite the first presenter, Ms. Pia Benosa, a research associate at the Center for International Law. Pia, you have the floor.
Thank you very much, Dawoon, and good afternoon to everyone joining us from Singapore and from the region. And to everyone else, good morning, good afternoon, or good evening. My presentation will be very short. It will give a recap of recent developments relating to MAS at the IMO. I recognize that from our registration list, there is a wide range of backgrounds, and to be able to ensure that we are all on the same footing about what MAS is and why this is such a critical subject in the law of the sea today, I will go through some preliminaries about what has happened in the last few years relating to this subject. Next slide, please. So before my presentation proper, I would like to invite your attention to a recent report that CIL published on its activities relating to MAS from last year. And this is a series of webinars as well on certain key areas where MAS is the anchor. And we took a look at several issues that are affected in the law of the sea by this new creature that is autonomous ships. So in different webinars, we discuss the relationship between MAS and the marine environment, MAS and flag states, MAS, maritime law enforcement, and maritime security. So please, when you have time, please feel free to browse through the report that we have made available in our website. And the link is right here on the screen. So those workshops were actually very high level, and we had invited experts who have already been writing about this subject. And so we didn't really cover some of the basics when we started to launch those webinar series. So I'm going to talk about some of those basics. Next slide, please. So there is a lot of talk, a lot of conversation about unmanned ships now, other than just the general discussion that is going on about mass. So what do we talk about really when we mention mass in our discussions? You will note from my second bullet that there are many acronyms that are appearing in the literature right now. And some commentators would say that in general, these unmanned maritime systems would be the umbrella term for these new class of ships or vessels. And there are many acronyms such that refer to whether these are surface vessels or underwater, or if they are unmanned or completely autonomous. And the configurations of those types of entities would vary depending on those kinds of characteristics. But our focus today is the consideration of mass before the IMO, and certainly before the IMO, the scope of discussions is much narrower. And we are not going to talk about the maritime security implications, for example, of like ship drones or drone boats that are more of the kind of the second picture in this slide. So the interest of IMO discussions is mainly as they relate to the types of vessels that are already covered under the different IMO conventions. So at the very start of the discussions before the IMO, there were also questions as to how the currently evolving topic will impact the law of the sea, which is the anchor also of the whole regime that the IMO is working under. And notably, the Law of the Sea Convention does not define what a vessel or a ship is. So in the earlier periods of discussions on mass, there has been a question on whether mass meets this requirement of being a vessel or a ship. But over the years that the discussion has been going on, it has become less controversial for my personal assessment. Instead, the stakeholders are considering the deeper questions on the application of the equivalences in the legal regime under the Unclass and the IMO conventions as they relate to the roles that exist in those extant instruments and what is forthcoming for the operation of mass ships in our seas. So some of the key issues that are really driving the discussions right now are as follows. So what is a master? What is a crew? And in the context of mass, what would fulfill the requirements under the UNCLOS and IMO conventions? Remote control operations would be an entirely new being under this regime. And so what kind of obligations and entitlements or responsibilities would have to be observed as far as these new entities come into play? And also there is a question of how to communicate with mass, communication between conventional vessels and these new types of ships, and also responsibilities of masters and crews when it comes to distress situations and how exactly that will play out. So that's just an example, and there are many other issues for consideration. Next slide, please. So within the IMO, I will just talk briefly about the beginnings of consideration in that forum of mass. And as far as my review of the instruments of the documents of the IMO goes, it appears that the first mention, the earliest mention, if not the first mention of autonomous systems dates back to MSC 95. when the UK provided information on its national approach to marine autonomous systems, and that contemplates both surface and underwater vessels. And the idea was that they wanted to establish technical liaison with international stakeholders on this subject. Later on in 2017, there was a joint proposal by 9 states for the conduct of a regulatory scoping exercise, and that received support within the committee. Later on, the procedural and substantive aspects of this exercise, of which entails a review of instruments under the MSC's purview, were actually starting to be threshed out from MSC 99 in 2018. And it was sought, well, the idea at that time was that MSC was going to take the lead on this issue and that the other committees of IMO could contribute afterwards. A working group on mass was also established. Next slide, please. And already during this stage, there were a wide range of views that were already being exchanged at that level. Well, our interest today mostly is the implications on and for mass with respect to Unclass, but the other issues is with regard to the sharing of information and lessons learned with other international organizations and UN bodies, including the Division of Ocean Affairs and Law of the Sea of the United Nations. There were also NGOs that advanced the view that at that time, there was not really a need for the urgent development of mass technology. And that is mostly for concern. Some of the organizations that articulated this view would actually be backed by a concern for labor in the maritime sector, which was perceived to be one of the most affected by the emergence of mass technology. At the same time, this series of activities did provide a venue for maritime industry stakeholders to exchange information on what they were already doing prior to the appearance of mass on the IMO agenda. And along with that, our efforts to try to see if stakeholders believe that potential inconsistencies within the legal regime of IMO and Unclass can be resolved at the IMO level solely, or will it actually require an amendment of Unclass itself? Next slide, please. Okay, so the regulatory scoping exercise that took place before the Maritime Safety Committee became the template for parallel action that was done before the legal and facilitation committees of the IMO. And these are some of the approaches that were taken. The question after review of the instruments that were within the specific purview of the different committees was whether it was going to work if the conventions were kept as is, or do they have to be amended in some parts, amended as a whole, or will there be totally a new need for a new instrument to facilitate the operation of mass, or none of the above? After much exchange, 4 degrees of autonomy were identified as a framework to approach this, although the documents that have been produced by the committees reporting progress on the discussions would usually say that this categorization of the degrees of autonomy is limited only to the conduct of the regulatory scoping exercises and should not prejudice the further development of norms under any subsequent codes or other instruments that will be developed. So here, very briefly, the 4 degrees of autonomy of mass that were looked at and as possible directions for the development of this technology are as follows. First, you have ships with automated processes and decision support, which is very much what the level of technology that is present already in ships that we have today, I believe. Second, are remotely controlled ships with seafarers still on board. Third, are remotely controlled ships without seafarers on board. And four are fully autonomous ships. So over the course of discussion the last few years, the general idea is that degrees 1 and 2 of autonomy would not present too much of a problem to the current IMO conventions, but it is the 3rd and 4th degrees of autonomy that would. Okay, next slide, please. In 2018, further progress on the consideration of mass would take place in the subsequent meetings of the MSC. Member states or groupings of member states actually volunteered to conduct the preliminary analysis of the different instruments under the MSC's purview. And in MSC 101, interim guidelines for mass trials were approved, and that has been relied on, I believe, by several countries that were already conducting trials at the national level. Next slide, please. Okay, in MSC 103, the working group on mass submitted their final report on their regulatory scoping exercise. And the report contained the following items. It's a good read. We are informed of the assumptions that were relied on and what the thinking was on how mass should be addressed in those instruments or in subsequent instruments. The working group concluded that following the regulatory scoping exercise, the best way forward for introducing mass in the IMO regulatory framework was through the development of a goal-based mass instrument. And member states were requested to submit output proposals on this. And there were also proposals for the establishment of a joint legal MSC and facilitation committee working group to coordinate further work on this subject. Next slide, please. In 2020, later in 2021, in MSC 104, a new output on the development of a goal-based instrument for mass was approved, and the target completion year is 2025. So that is quite soon. What was identified during this meeting was that the first step would be the finalization of a roadmap to have a common understanding of the further steps towards this process. So as regards the nature of the instrument that would be produced itself, it has been said that of course, at the initial stages, a non-mandatory instrument would be feasible. But later on, the ultimate goal will be the preparation of a mandatory instrument to address mass operations. So as I mentioned earlier, the legal and facilitation committees also were doing their own regulatory scoping exercises. And more or less at the same period, these processes were also finished. The legal committee also approved the new output measures to address mass in the instruments under the purview of LEG with a target of 2025. Okay, next slide, please. So where are we today with regard to the conversations on mass? There is a lot of progress on the work plan for the development of a mass roadmap. And as I said earlier, the MSC agreed to develop a non-mandatory goal-based code as a first step with a coverage initially of cargo ships, but also later at the same time assessing whether there would be room for the development of rules also for passenger ships at a later period. The working group on mass was reestablished and met during this period. And the earlier proposed joint working group was also established to facilitate the work on the development of a work plan. In addition thereto, besides the non-mandatory instrument, the working group also agreed to work towards the entry into force of a mandatory mass code by 2028. And there was an acknowledgement that it's quite a short time to take on this effort, but that the idea was that this effort will be supplanted by the experience in the development of mandatory code. A mass correspondence group was also established alongside the joint working group. Next slide, please. So for the joint MSc Leg and FAL working groups on mass, the activities are very recent. They had their first meeting earlier this month, from 7 to 9 September. And they were working on the findings that were already made by the different committees in their scoping exercises on the following common gaps and themes. And these are the main gaps and themes that have been identified throughout these last few years, really. It always comes back to these core issues. And to prepare the joint working group for further work that they will be doing in the coming years, an IMO seminar on mass was held prior to the first meeting of this working group, where academics and industry developers and authorities from the different governments that are making advances in their mass technology were invited to present and help inform the working group's current efforts. And Professor Beckman was among the presenters at this session. And one of the hot topics from the seminar was as regards to the issues that we have already been discussing in our webinars last year, which is really the interpretative issues arising from the interaction of the IMO and Unclass regimes. And I think the comments of the academics in Law of the Sea have been received positively, and it will be further considered by the joint working group in their further work. And Prof. Beckman will be talking more about those issues. So this ends my presentation. I just have one slide, and this is to introduce a new project of the Ocean Law and Policy team of CIL in developing a research tool for the International Maritime Organization's body of documents and wealth of resources. And this is a project that I've been working on with Professor Beckman. And we are just waiting for this to go to the printers. And next week, we expect to launch this by the 3rd of October. So I invite you all to please watch this space. This is the link in red. And you can also see the page directly from the CIL website. So I hope that this would be of interest to many young researchers and maybe junior government officials as well who are new to the processes of the IMO. And I would invite you, if you want to learn more about this tool, to type in the Q&A box and express your interest. And if we have time later on, I am happy to walk through some of the pages of this guide. Thank you very much.
Thank you so much for the great presentation. And Now, I would like to invite the second presenter, Prof. Beckman, who is the head of the Ocean Law and Policy Program at the Center for International Law. While Pierre was looking at the discussions at the IMO, Prof. Beckman will talk about the interactions between the MAS, focusing the interactions IMO conventions and Unclass focusing on MAS. Prof, you have the floor.
Okay, thank you very much. Good morning, good afternoon, good evening, everybody. Allow me to attempt to share my slides. Let's hope we get. Is that, and Dawoon, can you tell me, does the audience see the full slide?
No, Prof.
What do you see?
So I can see two slides.
Okay, so we will have to. All right, is that okay?
Yes, it's okay.
All right, fine. Thank you very much. I'm going to be speaking about the 1982 UN Convention on Law of the Sea, MAS, and IMO instruments. The outline of my presentation. First, I'll give an overview of the issues I'm going to cover. Secondly, the role of the IMO in the implementation of Unclass. Part 3 is Unclass and the manning of ships. Part 4 is the communication of MAS with the authorities in coastal and states and with other ships. And then 5, some conclusions. So I'll begin now, part 1, the overview. Let me start with a caveat. I'm an international lawyer who specialized in law of the sea and the 1982 UN Convention on the Law of the Sea, which I use the shorthand Unclass. I have a general understanding of the work of the IMO and its committees, but I'm not an expert on the details of the IMO conventions and annexes. I have little understanding of the technical issues relating to design and control of MAS. Very little understanding, keep that in mind. My research analysis focuses on the impact of MAS on the rights and obligations of flag states, port states, and coastal states as set out in the 1982 Law of the Sea Convention. The comments in this presentation focus on commercial ships and may not apply to warships or to autonomous surface vehicles and autonomous underwater vehicles employed by navies. That is another issue that is not under the rubric of the work of the IMO. Overview, Unclass is a framework convention that was intended to be updated by the IMO instruments with respect to the regulation of shipping in order to keep pace with the technological developments, because it was drafted in the 70s. In fact, many of its provisions date back to the 50s. So they intended that the UN organization with the competence to regulate international shipping would be updating it through its instruments. The provisions in Unclass, including those referring to the obligations of flag states with respect to vessels flying their flag, can be and should be interpreted in light of the IMO instruments dealing with MAS once they're adopted. Under both Unclass and IMO conventions, the flag state has the primary responsibility to ensure that ships flying its flag comply with the applicable rules and regulations on safety and navigation and ship source pollution. And therefore, the flag state that must have primary responsibility to ensure that the MAS comply with IMO conventions. This is the framework set out in the Law of the Sea, and most of the IMO conventions are completely consistent with that. There's obligations on owners, there are obligations on operators. Those obligations come through the obligations on flag states, and flag states then impose the obligations on the owners or operators. Next slide, IMO can impose obligations on the flag state to ensure that masts are continuously under the control of persons serving as the master or crew of the vessel. IMO can impose regulations in the flag state to ensure that masts are under the control and supervision of persons subject to its jurisdiction and control, and that such persons are able to communicate with other ships and with coastal authorities. Any responsibilities of the owner or operator of a mast should be imposed by the flag state, because it's the flag state that has the rights and obligations under international law. Okay, I'm moving now to part 2, role of the IMO in the implementation of the 1982 convention. IMO has ruled during the 9 years of negotiations leading to the adoption of Unclass. The Secretariat of the IMO, formerly IMCO, actively contributed to the work of the UN conference in order to ensure that the elaboration of IMO instruments conformed with the basic principles guiding the elaboration in Unclass. And there is a document called Implications of Unclass for the IMO, put out by Ledge in 2014. The implications of Unclass for the IMO, the study by the Secretariat, analysis of the relationship between the 82 Convention and the IMO instruments, covers many of the issues that must be addressed on the implications of mass on Unclass. Envisages other possible roles for the IMO in connection with the implementation of Unclass. And this is a quote from that document, toward the end of the document. I don't have the page number cited here. In addition to the new or modified functions and responsibilities directly or indirectly imposed on IMO by Unclass, it may be necessary to consider what other possible roles, if any, may legitimately be played by the IMO in connection with the implementation of the provisions of the convention that deal with matters within the field of competence of the IMO, particularly the provisions whose interpretation or application may be assisted by work within the IMO. And in my view, that is exactly what we are dealing with respect to the IMO. Now, Unclass contains many provisions which we scholars call rules of reference. They impose obligations on states to ensure that the ships flying their flag comply with or implement the IMO rules when exercising navigation rights or freedoms. Example is Article 39.2 with respect to ships exercising the right of transit passage in a strait used for international navigation, such as the Straits of Malacca and Singapore. Article 39 provides that those ships shall comply with the generally accepted international regulations, procedures, and practices for safety at sea, including the regulations COREG. But for safety at sea would include SOLAS, it would include STCW, etc. So this was a rule of reference which enables the 82 Convention to remain current, because the obligation under the 82 Convention is to comply with the current rules of 2022, not the rules as they existed when the convention was adopted in 1982. So this is the function of the rules of reference in Unclass, is to ensure that the details setting out obligations of flag states, port states are regularly updated, and the parent convention, the Unclass, ensures that obligations under that convention are to conform to the rules as they exist today. And they must also comply with the generally accepted international regulations, procedures, and practices for ship source pollution, which is MARPOL and all its annexes that are in force. Now, this document on Unclass in the IMO says reference may be made in this connection to the articles of the convention that relate to safety at sea and prevention, reduction, control of pollution. So again, it's maritime safety and pollution, which are the main function or the main responsibilities of the IMO. Since many of these articles refer to or presuppose the existence of international regulations and standards adopted by the IMO, and by reference to which states may implement the provisions of Unclass. So these are the key, right? Unclass is a framework convention. Many of its provisions can be implemented only through the specific operative provisions in other international agreements, especially the relevant IMO conventions. Unclass has numerous provisions requiring states to take account of, conform to, give effect to, or implement the relevant provisions in. And their phrases vary, but there'll be phrases such as the applicable international rules and standards, the generally accepted international regulations, procedures, and practices, etc. So the rules of reference in Unclass impose limits on the power of coastal state to regulate ships. This is another important because the whole issue is flag states versus coastal states. And the rules of reference, in some cases, put limits on the coastal state to regulate ships that are exercising passage rights through waters subject to their sovereignty, which would be the territorial sea or archipelagic waters. For example, Article 21.2 of Unclass provides that the laws and regulations of coastal states on ships exercising the right of innocent passage in their territorial sea shall not apply to design, construction, manning, or equipment of foreign ships unless they're giving effect to the generally accepted international rules and standards, which is the IMO rules and standards. And therefore, this is very important with respect to autonomous ships, because it means that a coastal state would not be able to prohibit mass from having the right of innocent passage through their territorial sea, because the laws and regs of the coastal state on innocent passage cannot apply to manning of a vessel unless it's giving effect to the generally accepted international rules, which would be those set out in, for example, SOLAS or in the new code governing mass. The generally accepted rules and standards are those set out in the IMO conventions and their annexes. I'll now move to part 4, Unclass on the manning of ships. This has become a very widely discussed topic, the manning of ships, particularly the role of the remote control operators. Now, first is the definition of a ship. Unclass uses the term ship in some parts of the convention, uses the term vessel in other parts of the convention, depending on which of the committees at the UN conference dealt with that issue. And Unclass does not contain a definition of either ship or vessel, which my argument is good. Unclass also contains references to master, to officers, and crew, but it doesn't define those terms either. And because there's no restrictive definitions of those terms in the convention, the IMO can interpret the terms in the IMO conventions and annexes in light of technological developments, including mass. So this is again the way the rules of reference in Unclass can be updated by incorporating definitions of master, officers, etc., in light of the technological developments. Now, duties of the flag state. This is an article that is given academics, and there's no lot of discussion or room for discussion and a lot of different views on this. Article 94.4b of the Law to Sea Convention specifies that such measures by the flag state must ensure that each ship is in charge of a master and officers who possess appropriate qualifications. Again, for vessels with a master and officers on crew, of course, this is laid out in STCW and other conventions. And 94 also says, and that the crew is appropriate in qualification and numbers for the type, size, machinery, and equipment of the ship. 94.4c specifies that the master, officers, and to the extent appropriate, the crew are fully conversant with and required to observe the applicable international regulations on safety at sea, coal regs, and pollution, and the maintenance of communication. So the issue that immediately arises, does Article Y94 say that the master and crew must be on board the ship? No, they do not. It says each ship must be in the charge of a master and officers, and that the crew is appropriate in qualifications depending on the machinery and equipment. So I would argue that a remote controlled ship may still be in charge of a master and officers, even though the remote control operator is on another ship or is based ashore. 94.5 says, in taking the measures called for in paragraph 3 and 4, each state is required to conform to the generally accepted international rules, regulations, procedures, and practices. That again doesn't give states much discretion. If the IMO adopts a mass code, then the measures that flag states must take are to conform to the generally accepted international rules, regulations, procedures, and practices once that code is issued and it's binding on all members under SOLAS, for example. Article 94 on autonomy levels 3 and 4. In adopting international regs on math at autonomy levels 3 and 4, that's the remote controlled by a remote control operator or completely autonomous. The IMO should include a provision on the functions and responsibility of the person or persons who would serve as the master. Nothing in the law of the sea that says the master must be aboard a ship. Master may be a person fulfilling those functions that is located elsewhere. Level 3, a master could be overall in charge of a ship and the voyage and supervise remote control operators. Level 4, the IMO possibly could articulate the qualifications and experience of a person under the jurisdiction and control of the flag state who would be responsible as the master for the voyage of a fully autonomous vessel. It would assume control in an emergency. This is pushing it a little bit, and the IMO will have to discuss this with the technical experts, but I would argue it's possible. IMO regulations should also set out the requisite qualifications of the master or officers, including qualifications in seamanship, navigation, communications, and marine engineering. And this course is being discussed in detail at the IMO. The location of the remote control operator has been a point of debate among law of the sea experts as well as perhaps at the IMO. Question is whether the IMO should require that the remote control operator be located physically in the territory of the flag state so that it's clear that the flag state has jurisdiction over the remote control operator. In the IMO seminar that was held a couple of weeks ago, there was difference between the legal academics that were present on this. My personal view is that the math code could require that the remote control operator is subject to the jurisdiction and control of the flag state, and the flag state's responsible for their acts, but they may not, I'm not convinced that it's necessary to require the RCO to be physically present in the flag state. It may be advisable to require that the master and the remote control operator be physically located where it's guaranteed that they can maintain continual contact with the mast. This, to me, is an issue of communication. The key issues, whether the person designated as the master under the IMO regulations is able to ensure that the ship complies with the applicable international regulations concerning safety at sea, prevention of collisions, prevention, reduction, control of marine pollution, and the maintenance of maintenance of communications by radio. That's what Article 94 of the law, the Sea Convention, provides. And if the IMO can draft rules with the help of the expert that the master is able to do that, the master doesn't have to be aboard the ship, in my view. Whether the IMO could amend the relevant laws and regulations for these four matters to take mass into account, and it would protect the interests of other ships and port states and coastal states. Because we're not talking only about the flag state here, we're talking about the potential risks that a mass might pose to other ships or to port states and coastal states. Next part of my presentation, communication of mass with authorities in the coastal state and with other ships. This is an issue that as I reflect on the issues becomes, I think, critically important. More than where the remote control operator is located or whether there's crew on board is, can that autonomous ship communicate with the authorities in the coastal state and with other ships? And can they communicate with the mass? To my view, if the communications resolved, most of the issues disappear. Academics, lawyers, law of the sea experts have raised the issue, how can a mass fulfill the duty to render assistance, which is an obligation under the law of the sea convention as well as under SOLAS. Some scholars have raised concerns as to whether a mass with no crew on board could fulfill their obligations under Article 98 to render assistance to persons in distress at sea. My view on that is that Article 98 must be interpreted in light of the fact that the mass would have no crew on board, no accommodation for passengers, and no food. Mass should be able to, however, the mass should have communications equipment and technological devices on their vessel that they should be able to visibly identify persons in distress. And if so, the remote control officer or the mast could notify search and rescue services and other nearby vessels. The IMO might also consider requiring masts to have lifeboats that could be lowered by the remote control operator in cases of persons in distress at sea. So my view is there's a little ingenuity that can solve this problem. Similar duty to render assistance, as I said, under SOLAS. So that I haven't looked carefully at what the IMO MSC has recommended on this obligation under SOLAS, but I expect the issues would be similar. Communication between mass and coastal authorities, to me, is critically important. Authorities in the coastal state must be able to communicate with an autonomous ship or the persons in control of that ship concerning matters such as compliance with regulations of the coastal state on mandatory ship reporting, vessel traffic system, sea lanes or traffic separation schemes, compliance with obligations under Unclass following an incident of navigation. There's an incident of navigation in the territorial sea. The coastal state has an obligation, or at least a right, to communicate with vessels that have been involved. Compliance with Unclass obligate rules on innocent passage when exercising passage in the territorial sea. There's a whole list of activities which would make passage innocent, and sometimes the coastal state has to have the ability to communicate with a vessel exercising passage to make certain it's not infringing the rules in Unclass. Compliance with the rules on archipelagic sea lanes passage or transit passage is similar. Communication between mast and Coast Guard vessels, another important problem. The mast or the master or remote control operator must be able to communicate with Coast Guard and naval vessels of a coastal state or archipelagic state concerning incidents in the territorial sea or archipelagic waters with respect to what if there's a collision or other incident in navigation, there's a pollution incident involving a mast, request by a foreign naval vessel verify the flag of a mast. Again, there is a right of visit that would apply. Attempt by a foreign naval vessel or Coast Guard vessel to exercise right of arrest of a mast. There are cases where At least academics are talking about mass being used to smuggle drugs or smuggle people. The Coast Guard has evidence that a mass might be involved in some illegal activities. They have to be able to exercise the right of arrest. How do they do that if there's nobody aboard? This technological problem will have to be resolved. Again, by attempt to by a Navy or Coast Guard to exercise hot pursuit against a mass that is engaged in illegal activities, you normally give a visual or auditory signal. The question is whether a mass can receive the visual or auditory signal. These are, again, technical issues that the experts should be looking at. Another issue that comes to mind is the communication if there's an emergency on a mast. Who does it communicate with and how? Must be able to communicate with the coastal authorities and other ships because they could be put at risk by the existence of emergency on a mast. If there's a fire aboard the mast, power failure aboard the mast, technical communications resulting in it not being able to communicate with the remote control operator or authorities in the flag state. Technical communications problem result in it not being able to communicate with other vessels. We have to think about and have rules that deal with this issue as to how the mast would be able to send up signals for the other vessels would avoid it, etc. And unauthorized boarding of a mast, what kind of signal would be put out by the remote control operators or by the person serving as master or by the vessel itself? To whom and then who responds? Okay, now my final conclusions. The rights and obligations of states under the 1982 Convention will be impacted by mass vessels. Unclass is almost impossible to amend. Okay, so it's not a question of amending the parent convention, it's a question of amending or passing new regulations of the IMO. Unclass provisions can be updated in light of mass if they're interpreted in accordance with the IMO. If the Unclass provisions are interpreted in accordance with the IMO conventions and annexes or with a mass code, if it comes to that. In developing a mass code, the IMO should take into account the provisions in Unclass and the role of the IMO establishing rules and standards for flag states, coastal states, and port states. Key issue in developing the mass code will be communication between that vessel and other vessels and communication between mass and coastal states. Thanks very much. I'm very happy to enter into a discussion or attempt to respond to any questions that anybody may have.
Thank you so much for the excellent presentation. And in fact, even though I have been working on the mass, I learned quite a lot from both presentations. We are waiting for the questions. So please type, if you have any questions on the presentations, please type your questions into the Q&A box at the bottom of the Zoom screen. While we are waiting for the questions, I would like to ask Prof about the remote control operation, because you mentioned that in part 3, there were controversies over the jurisdiction of flag states in terms of the location of remote control operation. So can you specify the questions, questions that discussed at the IMO seminars?
Well, I'm not sure. I have not privy to all the discussions at the IMO, but I know in the workshop or in the webinar that we had a difference of opinion between the different scholars that were present at our workshops. And at least one of the experts we had said that to resolve the issues, it would be safer to require the flag state to have the remote control operating from their territory so they would have jurisdiction over them. My own view is I'm not sure. Flag states have obligations with respect to the ships flying their flag. They use the class societies to make certain that the ship complies with the international regulations. In many cases, the ship flying a flag of a state may never actually come into port in that state. So the real issue is, do you have jurisdiction and control over, if you have a remote control operator sitting in the Philippines or Indonesia, is he subject to your laws and regulations? And if there were, again, there are other issues people raise. What is the liability of the remote control operator as such? To me, that's like asking, what's the liability of the master? The overall responsibilities ought to be, in my view, the responsibility of the flag state. The flag state determines perhaps whether it's the owner or operator or the master that may have liabilities under their laws. I guess the question, if you had the remote control operator located within your territory and they were negligent, whatever, then you'd be able to arrest them if that's what you wanted to do. But you could also make them subject to your laws. The other point that's made is that the ship is, the master that's now of a foreign vessel may be a foreigner, and he may never come to the jurisdiction of the flag state. He's on the vessel and the flag state's laws apply, but technically if he's an Indian national aboard a ship that's in the South Pacific and there's a collision and he's negligent, well, technically the flag state has jurisdiction over him, but he is a long way from that state. So I'm not convinced that the remote control operator, or at least I remain, somebody has to make an argument that convinces me that they would have to be located in the, that relates to another issue that I've thought about, and that is, would your remote control operator, let's say you're sitting in Oslo, Norway, would they have the same ability to control a ship and communicate with it when it's in the Indian Ocean or the South Pacific or the South Atlantic? Or would the communications issue require maybe that your remote control operator particular voyage it might be better if that remote control operator were closer to the voyage of the vessel. But again, I guess this depends on the communications between the ship and the person in charge of it and the flag state. I'd expect there also has to be the ability for the flag state to communicate with the ship and with the remote control operator who's in charge of it. Pia, do you have any thoughts on these issues? Feel free to interject.
I have very little to add, but in the Q&A, there is a comment that relates to this as well. And I think you touched upon it at the end of your comment, which is that there could be issues with connectivity. And for now, we have yet to see how the technology is going to evolve and whether it's going to be a seamless process. And I mean, during our chats, Prof, we did talk about, would it be possible for a network of these remote control stations to actually be activated in the course of that multi-stage or international voyage. So it really remains to be seen.
That's exactly the point that I've been thinking about. In other words, if the vessel's moving from Northern Europe through the Suez Canal across the Indian Ocean on its route to Japan, is it realistic to expect that there's connectivity, say, from a remote control station in Norway for the entire voyage, or would it make sense to have remote control stations along the route, and that you might have a person serving as master for the entire route, but the remote control operations may be taken over as you move from one area to the next. Now, again, I'm a simple lawyer. I don't understand the communication. But to me, it's an issue that I thought about, and I'm thinking about this when states said, well, it must be the flag state. Because your major flag states are Panama, Liberia, Marshall Islands. I can't imagine that the remote control operators are going to be sitting in, I happen to have visited Marshall Islands once in Madro in Main Island in the Marshall Islands, and they're going to control ships that are moving through the Suez Canal, and that you're going to have a group of experts sitting in the flag state. I mean, you could have the obligation on the flag state, but I'm not sure the physical location of the remote control operator must be within the flag state. But again, it might be my ignorance about the communications issue, but I've thought about that as the most important issue. I think once the communications issue is resolved, and we know that flag states can communicate with that vessel that has no crew aboard, and that other ships can communicate with it, then electronically, but that assumes that somehow, again, you might be coming across in the path of a fishing vessel, or a fishing vessel that without electronic means may be in your path. How do you communicate with that vessel and tell it to get out of the way? That's the sort of issue that I've, as a lawyer, thought about. Perhaps the technical people have answers to that I'm not aware of.
Thank you, Prof. So yeah, as Pia mentioned, that there is a comment in the chat box for this question that Ashish Akarya mentioned that many flag states are remotely located in Pacific Islands. So it is unlikely that there can be good connectivity, which should be required. So I feel like it is the same approach that Prof mentioned. We are still waiting for another questions, and then we've got the one questions. So
okay.
Further to the question from Ashley O. Further to the issue of communication, Article 98 of Unclass provides for the duty of states to require shipmasters to render assistance to persons in distress. Has there been any discussion on whether MAS must also be programmed or built to be able to provide some form of assistance in such distress scenarios in order to satisfy Article 98? Prof,
okay, very good question. I said something about it in my presentation. I must admit that I have not researched what discussion there was at the Maritime Safety Committee on this issue. I assume they must have discussed it because there's a similar obligation in the MSC, as far as I recall. My view on this is that it is an obligation in the convention, and how you program it would be another issue. I raised this in my presentation. Assuming that the MAS had the technical ability to see other vessels, etc., or that somehow another vessel could communicate with it, that we are thinking we have whatever, there's been a collision and there's life is at risk, please assist. The question, I guess, is whether the remote control operator or an automated, completely automated vessel would be able to respond in some way to that. This is one of the technical issues. I think Aldo Kirkhope mentioned on this when he and his presentation at the IMO seminar. Could a vessel be required to have lifeboats, for example, and then assuming the communications issue could be resolved, the remote control operator or even person that takes over in an emergency could release the lifeboat so that they could be utilized. Otherwise, I think it has to be, certainly you can't take on board persons and take care of them. You have no facilities to do that on a mast. On the other hand, you could radio for assistance of other vessels in the area, assuming the communications is there. One of the difficulties of communication is going to be, again, even thinking of communications, if you're at the Port Command Control Center in Singapore and you're monitoring hundreds of vessels, do you know which ones are mast? Do you know which ones are remotely controlled? Which ones are completely autonomous? And do you warn other ships if necessary when that's the case? These are all issues that I'm not sure that the experts at the IMO thought about, that someone is going to have to consider. Exactly what, and to me, the communications issue is the big issue. How do you program an autonomous ship so that there's collision avoidance, especially if it's a small vessel that may not be easily seen. There's a small fishing boat. How do you ensure that it might try to get at night? How do you try to ensure that collision's avoided? You have nobody on the bridge. You have so on and so forth. These are technical issues beyond the competence of a simple lawyer, but I think these are issues that we have to the IMO will have to address as the experts.
Thank you, Prof. I've got a question to Pia that the Maritime Safety Committee and Legal Committee and Facilitation Committees have been working on the MOS, and they have been conducted the regulatory scoping exercise. But Maritime Environmental Protection Committee has a lot of things to do, so they haven't touched upon the MOS issue properly. And I'm wondering if there is any gap on this issue at the discussions at the IMO.
Well, I'm not privy to any of the real reasons why this the issue has not been taken up at the MEPC. But as I said in my slides earlier, it was reflected in some of the earlier MSC documents that all the committees have been given this preliminary information, and they were given the opportunity to come on board at a later point. But I believe through some conversations that I think Prof may have more information on, that because of, as you said, because of the workload of MEPC, one other consideration is that they are going to move along the same lines anyway, that the issues that will be important to the MEPC will be threshed out in the MSC as it relates to the safety of navigation and how you could avoid incidents that could result in pollution of the marine environment. So it's, I believe that is one of the main reasons, which is that it's going to be more or less the same track that will be followed. But as for gaps, I think it's expected that there will be some questions on whether, as far as those incidents are concerned, and the likelihood that they are going to happen, will that be covered enough by the future discussions that will happen in the joint working group? But I do believe that this will be a holistic point of discussion at a later stage as we get to the target dates for the codes.
Prof, would you like to add more on this issue?
Yeah, I'd had conversations with a couple of people, and they suggested that the main reason that the MEPC is so busy with so many other issues relating to black carbon and many other things, that and that the issues from the point of view of the MEPC probably very similar to the issues that the legal committee and others are working on. So that once those kind of, especially the communications issues are resolved, that the MEPC would probably be referred to it, but they probably would be asked if they have anything to add and perhaps not. I know the legal committee looked at the compensation provisions, for example. So I don't think it is a major issue. MSC is obviously the main committee. Legal was going to have something to say and fell, but it's not. One of the issues I guess I've thought about with respect to major pollution incidents involving a FAL. What if a autonomous ship, a MASS, were to collide with an oil tanker, and the oil tanker is the MASS's negligence or fault? Normally, the position of the flag state often is to arrest the offending, and especially if it's an oil tanker. You don't have that option anymore with a MASS. Whether that in any way affects how the flag states would look at it, or whether there's any kind of bond required for damage to their environment or to their coastline from MASS, it's quite a different issue. But again, the obligations are primarily going to be on flag states. So that's a question again of what about fault in terms of fault between owners and operators and masters and whatever, that's all for the private lawyers to worry about. The international lawyers are just thinking about it in terms of flag state versus coastal state.
Thank you. We've got a question in the chat box. In addition to Unclass and IMO, are there other frameworks under which rules relating to autonomous ships could be developed? For instance, could the ISA adopt regulations relating to autonomous underwater vessels used for seabed exploitation?
My own view is that the experts are at the IMO. The people at the ISA may know a lot about seabed mining, but they probably don't know a lot about safety and pollution from ships. So in my view, it would be the responsibilities of the IMO to put the rules in place for safety and for pollution of the vessels engaged in any way in seabed mining. I think the IMO is the UN specialized agency responsible for shipping, especially commercial shipping, and any ship involved in seabed mining would be a commercial ship. So in my view, this would be should be responsibilities of the IMO, and the ISA shouldn't try to take this on. That's my personal view. Pia, do you have any different view on that?
Well, I'm just thinking about the context that I provided in the earlier portions of my slides, which is when you have, as part of these seabed mining operations, when you have much smaller types of autonomous vehicles or devices, where it's much more tricky to ascribe to them the status of being a ship or vessel, that it might need, as you said, Prof, to bounce back on the main ship or the main organ that is flagged to a state in order to observe those applicable rules. But I guess what I was just thinking about was that it doesn't come very clearly whether those kinds of smaller autonomous vehicles will directly come within the purview of the IMO regime. And this is something for further consideration.
Okay, if you're talking about those small things, I take your point. And I guess that's the question of whether it's back to the Law of the Sea Convention. There's no definition of a ship or a vessel. So are these, is a barge covered by the IMO regulations? I'm not even sure. You have to be a ship, you have to have your own control. I mean, these are technical issues which obviously someone should be regulating them, and someone should be ultimately responsible for any pollution damage they cause, or if they collide with another vessel or someone else who's using the high seas. But to me, this is something that the ISA should be consulting the UN Division of Ocean Affairs and Law of the Sea, and perhaps the IMO, to determine exactly who should have the responsibility. What you don't want is conflicting sets of rules by two different organizations.
We've got several questions more.
Okay, so, good.
The question from Stefan: are there any regulations in Unclass that concern or influence cybersecurity, which likely will be a major concern for MAS? So this is context with the communication satellites were operational since 1976.
Okay. The Law of the Sea was drafted in the 70s. The provisions on ships actually were word for word the same as the 1958 convention, which was drafted by the International Law Commission in 1956. No one thought about cybersecurity in 1956. They didn't think about it in 1982, and therefore the Law of the Sea Convention is completely silent. It's a bit like submarine fiber optic cables. It's a the new problem which technologically technology's created a challenge for the legal regime, and the lawyers are going to have to try to catch up. So as far as I know, nothing in the convention. Then the question would be, to what extent is telecommunications and cyber attacks going to be the responsibility of the IMO, or is it somebody else? Very interesting question. I pray I don't have a clear answer.
Thank you, Prof. Next question is from Vishal. If the mass controls be remotely hacked and the vessel now comes under the control of an unauthorized entity or persons, could this be treated as the piracy?
No, because piracy is very carefully and narrowly defined. It's acts of violence or an act of depredation by one ship against another ship. Must be a use of force against the ship, and that would not apply to a cyber attack. So you're going to have to find another rule that creates legal issues relating to cyber attacks on ships, I think. Maybe a gap. You might need an International Maritime Crimes Convention of some kind that covers cyber attacks, but it's very difficult to fit it under Unclass, because Unclass says piracy is the one exception to the principle that ships on the high seas are subject to the exclusive jurisdiction of the flag state, and that one exception remains the single exception that's existed since the 50s. So you can't loosely interpret something when it says acts of violence, etc. Cyber attack's not an act of violence in the traditional way.
Pia, do you have any idea on this issue?
I have no further comment to add on the piracy point.
Okay. The last question is from Kong. Is this new development under the IMO with the autonomous ships or vessel not conflicting with the right to work for seafarers? How is human rights at sea being considered in this new move?
Okay, very good question. I think that's going to be a question for, there are people that say, given the difficulties of hiring seafarers, the technological developments will make it easier to operate shipping firms. On the other hand, there's people that are very concerned about the labor supply countries may suffer in the long run because they provide large numbers of the crew of vessels and their jobs may be lost. I don't know enough about the economics of it. We'd have to look at statistics. The question would be, I guess, if you're thinking ahead and you're from the Philippines or India or countries that supply a large number of seafarers as well as officers, you may be thinking about how do you retool your marine institutions in order to prepare people for the new technology. And it might be the states that are ahead of the curve on this that might be the ones that are engaged as remote control operators, etc. But there's no convention which would certainly prohibit countries from developing mass vessels because it would mean that fewer laborers are required. This is just like high tech in industry worldwide. As Amazon uses technology in its warehouses where workers are lost, and that's a sign of what some people call progress, and other people look at it the opposite way. But as far as I know, no, MLC is there. MLC, whether the MLC has to deal with, again, it's laborers aboard ships. I guess the question is, what kind of labor standards might there be for persons that serve as remote control operators or as standby in case that's a slightly different issue. My guess is the IMO might deal with it first under SDCW. And whether the Maritime Labor Organization would try to come in on this, I don't know enough about that issue. Interesting issue, though.
Thank you, Prof.
Sorry, if I may add, I did mention earlier in my slides that when the issue was first emerging in the IMO, there were some non-government organizations in consultative status with the organization that did submit communications precisely on this point. They were worried that it would affect the rights of seafarers or their job security. But I don't think there has been much traction on that issue. I don't know if it's out of a belief that this is still a long way from being the general mode of transportation in commerce. And at the same time, within the IMO discussions, there has been that question of whether a remote control operator has to have a status of a seafarer. And two approaches can be had on that, which is one that your current seafarers may be trained for this specific purpose of being remote control operators, or should it be that the technical people who are already involved in mass trials and already have the technical expertise in operating semi-autonomous equipment will be given this status without having the kind of experience and background that our current seafarers at sea have today. So those are some issues that may be up for consideration. There's also a lot of talk about just transition, especially as we move towards a carbon efficient technology and the jobs that will be affected in the transport sector. But I don't think there is much attention on the effects that mass will have on this for now.
Thank you, Pia, and thank you, Prof. Before closing our webinar, I would like to take an opportunity to introduce our CIL guide to the International Maritime Organization. If you are working on the IMO, or if you are working on the issues relating to IMO, it would be great the material to have a look at. So Pia?
Thank you, Dawoon. As I mentioned earlier, this is a project that has been in the pipeline for a while, and I'm very grateful to have the mentoring of Professor Beckman as I worked on the content of the guide, and we did enjoy very much working on this and thinking about the really interesting organization that the IMO has become as it tackles new issues relating to commercial shipping and its interaction with the law of the sea. So this is the CIL guide to the IMO. It's a resource that we have developed for junior researchers and early career government officials who may be working on projects concerning areas of specialization of the IMO. And this is born of our thinking that when we do our own research about the topics that are being discussed by the IMO, we have some difficulty in accessing materials or making sense of some of the content coming from a law of the sea background. So this is very much a product of our own research processes in regards to this issue. So I will just show some of the pages that we that this guide is bound to have. The contents are essentially as follows. A background on the IMO, its creation, who are the stakeholders, what are its basic documents, what are the different organs by which the work of the organization is delivered. What is the process of rulemaking at IMO? What makes it unique in international law and in the systems of treaty making? And how are its procedures observed? And how are the instruments adopted or amended? As we have been discussing, the relationship between IMO and Unclass and how the IMO approaches new issues that may have not been previously contemplated by its conventions, the majority of which are from the 70s and 80s, I believe. And we do know that much of the work of the IMO is through the development of new guidance or codes that evolve from out of those conventions. So I will just very quickly give you a showcasing of the pages. As I said, we hope to have this uploaded to our website by early next week. So please do check out the CIL website and the specific page that pertains to this. And of course, the information that is contained in this guide will continue to evolve. So it is the hope that years from now, junior CIL researchers will be able to supplement the content of the guide and keep it up to date. Although, of course, we are an academic research institution, so it's there is a high premium on getting it really up to date regularly. So yes, I think I will just keep moving the pages. If Prof wants to say something, it will be a good time to hear from you as well.
No, I would just like to thank Pia for all the hard work she's put on this. We've had many, many long discussions as to what the content should be, how it should be presented to be user-friendly. We've had meetings with and we'd like to thank the Attorney General's Chambers of Singapore. We had a meeting with them on a draft, and they gave some very useful suggestions on how we could make it more user-friendly. So this is a guide which we hope would be of extremely good use for government officials that have to deal research dealing with the IMO, or academics or people in industry that have to deal with it, to quickly get you into the documents. Sometimes otherwise you see references and you have no idea what it is that they're referring to, or you hear insiders from the IMO talking about using acronyms and symbols and years, and you don't understand what they're referring to and whatever. This has enabled you to bridge that gap a bit, to be able to very quickly find out what's available on the IMO main webpage, what's available on the IMO docs webpage, where do you find copies of the official copies of the documents if they may not be available on the IMO websites, etc. So we hope that it'll be useful. It'll be even better if we get feedback from people as they begin using it, if they find gaps or mistakes. We'd be happy to receive them. I should say Pia will be leaving us very soon. And I guess we could announce that Pia will be joining the legal department of the IMO. So we're sorry to see her leave, but we're very happy to that she has found a position that will enable her to utilize much of the what she has learned during her stint at IMO, or sorry, stint at CIL, I guess. So that's as much. If again, we encourage people to check the website. We hope to have a print version of this document available also at a very reasonable cost. And the idea is that, but it would also be available to users from our website to very quickly access it if there's a particular issue you'd like to address, or if you had an IMO meeting and you want to look something up, you'd be able to quickly call it up on your iPad or even iPhone from our website. So that's it, I think. And Pia, anything else you'd like to add after my comments?
No, thank you, Prof. I'm good.
Okay, thank you to all our presenters today. I would like to wrap up this webinar, and thank you so much for attending this webinar. I hope you enjoy the rest of the day. Thank you. Bye-bye.